Patricia Van Haren, family law attorney. Many people don't understand what family law mediation is. So today we're going to discuss 5 myths about family law mediation. Number 1, my spouse and I don't agree on child custody, so mediation won't work for us. Most couples don't have agreements when mediation starts. The only agreement that is needed at the start of a mediation is that the couple does not want the future of their children determined by a stranger and they want to avoid court. The rest of the agreements can be made in the process. Number 2, my spouse and I don't communicate well, so we need lawyers to run the divorce for us. As a mediator, I act as a guide for the communication between the couple. Mediation is not only for couples that communicate well. Many times a couple learns how to communicate about important issues during the mediation process as they become accustomed to having calm, direct, and brief communications. This can help them learn to co-parent long after the divorce is done. Number 3, the mediator represents both of us in our divorce. As a mediator, I do not represent either party in the divorce. My office will prepare the paperwork that is needed to make the divorce legal, but I am acting as a neutral through the process. If the mediation fails, which rarely occurs when both parties are dedicated to the mediation process, the parties will hire their own attorneys. Each party may also use a consulting attorney during the mediation case to give them legal advice about the agreements being made. Number 4, my spouse has all the money, so the mediator will be biased because he's paying the bill or she's paying the bill. A mediator is a neutral, and therefore they must be impartial. It doesn't matter who's paying the bill, as ultimately when support and property are divided, it will take into account any fees incurred during mediation for the mediation. The mediator should have had significant training and should not be biased against either party. Our goal is to work towards the common benefit of the family, not for either party. Myth 5, mediation can't work for high conflict families. Mediation is a much better alternative for high conflict families than prolonged litigation. Litigation only adds to the conflict between the parties. Mediation actually reduces the conflict as the parties see that they are able to come to agreements with each other during the process, and they're able to learn to communicate in a better way. I've been brought in prior to trial in highly litigated cases to mediate and have been able to settle the most high conflict cases through mediation. Any questions about these myths or any other questions, feel free to shoot me over an email or give me a call.